So it is my good fortune to introduce you to my guest, Tony Hinson. I'm going to give you a little bit about his bio, and then Tony and I are going to have a discussion about estate planning around IRAs, and specifically around the Secure Act. So here's a little bit more about Tony. He's an attorney at the law firm Sherrard, McGonigal, Tizano, and Lind. Tony is a Poulsbo attorney with over 22 years of legal experience. Tony maintains a practice focused on estate planning, elder law, estate and gift taxation, guardianship, and probate matters. He practiced with the IRS estate and gift function for over 8 years and uses that valuable experience in serving clients with large and complex estates to maximize their ability to effectively provide for their family and charitable organizations through lifetime giving and careful estate and trust planning. A retired lieutenant commander with over 23 years of active duty and reserve service in the U.S. Navy JAG Corps, Tony is keenly aware of the unique issues facing military veterans and enjoys working with them to successfully integrate their retirement and other veteran benefits into their estate and retirement planning. Tony is blessed to live in Poulsbo, right with me, and it's a great community. And he spends his time being the best husband he can be with his rock star wife, Kim Hinson, and the best dad he can be for his two amazing kids, Jonathan, who's 13, and Elizabeth, 11. Tony, thank you so much for being a guest on Sound Retirement Radio.
It is fantastic to be here, Jason. Thanks for the invitation.
Well, this is going to be a good one. Now, what's interesting, I just want to run this by you, and this was probably more clickbait than anything, but I saw somebody write an article recently that claimed that the Secure Act was insignificant and didn't really matter for most people. What are your thoughts about that?
That amazes me, Jason. The Secure Act, from an estate planning point of view, the Secure Act changed everything. I mean, we were in a regime where we had the ability to leave an IRA to a spouse and then to our children. We could leave them essentially a lifetime annuity. And suddenly on December 20th, we had about a week and a half, and January 1st, the world changed when it came to IRAs and estate planning. So that's an interesting clickbait link.
Isn't that interesting? Yeah, I some of the stuff people put out there, I know it's just because they're trying to take the contrarian approach to the headlines, but I think this is really significant, and we're going to dive into it. But before we do, I want to ask you a little bit about your practice, the work that you're doing now. And one of the things that has always intrigued me and it makes you such a valuable resource, especially right here in our community, but for people all over the country, is the fact that you had this unique opportunity to work with the IRS, specifically around this area of estate tax and gifting. So can you fill in the holes there a little bit? Tell us a little bit more about that experience and what you learned from that and how you apply that to your practice.
Absolutely. It was a great opportunity. I went to work with the IRS in Honolulu, Hawaii, believe it or not.
Oh, wow.
My wife was still active duty Navy. We moved around a little bit, and the IRS is pretty good to its people, so I was able to move around to a couple of different duty stations, ended up here in Seattle. The work itself was fascinating. What my job was essentially examining relatively large estate tax returns prepared by some of the best practitioners in the country. So I got to arrive on the scene after this very complex planning had been put in place and examine these returns, and I feel like I learned at the seat of the masters in a lot of ways.
That's pretty cool. That's a neat planning opportunity. It gives you some insight that a lot of people may not have necessarily. So
absolutely. The one thing I did miss about the practice, IRS was a great place to work. I know it has a negative stigma, but
Sure.
A lot of really good people work there. But you don't really have a client. You've got the U.S. government as your client, and he or she is a pretty cold and impersonal person to work for. So I really missed that one-on-one interaction working with the client in private practice, which is part of what ultimately led me back to private practice.
Okay. So big picture, before we get into the Secure Act, tell me about IRAs and estate planning. What are some of the common things you hear from people as you're helping them with estate planning around their retirement accounts?
Well, the biggest thing is that in the past, I'd say 15 years, IRAs themselves have become a much more important part of people's estate plan. When I first started working with the IRS back in 2000, I'd look at large estates, and the IRA itself would be maybe $100,000, $150,000, which is a lot of money, but we're talking $5, $6, $7 million estates. Back in the old days, we had a $2,000 per year contribution limit. People weren't rolling 401ks over nearly as much. These days, the landscape has entirely shifted.
Mm-hmm.
You can look at a smaller estate than the large ones I looked at, where the IRA is 30%, 40%, 50% of this estate.
Wow.
Because people have done exactly what folks like you have told them to do. They've saved for retirement. They've done it diligently. They've invested. They've stayed invested. And at the end of their careers, that IRA is their largest asset. And it is a somewhat challenging asset to integrate into an estate plan. So that's been the largest change, I think, is that just the size and the percentage of these IRAs, they've become enormous.
Why is that? I just heard a news blast from Fidelity recently that there are more 401k and IRA millionaires than ever because of this run-up, partially because of this run-up in the stock market. But why has it become challenging from an estate planning standpoint when one of the largest assets that people have are these IRAs and 401ks and retirement accounts?
Great question. And it really goes to the heart of why such integrated planning is necessary with an IRA. You can have the most carefully drafted trust or will in the world. Everything is done properly. Trusts are set up. Funding is done immaculately. It's a beautifully crafted estate plan with the large IRA sitting on the side and no beneficiary designation for the IRA. The key, Jason, is that IRA itself does not pass per the terms of the will or trust. It is going to pass entirely with respect to that beneficiary designation. So that's one challenge, is making sure that the IRA itself is integrated into the estate plan. The second is that the rules for IRAs, which we'll talk about here in a second, I'm sure, they don't really care what's in your will or trust so much. The distribution rules, the inheritance rules are driven much more by the Internal Revenue Code and the regulations than all the drafting that the estate tax attorney can do on the side. So working the IRS rules into the overall estate plan is the trickiest part. The baseline question is, do you have that beneficiary designation in place that works with the estate plan?
How much money does somebody need to have in the retirement accounts before they really need to be thinking about advanced planning techniques, before they really need to be thinking about having an attorney help them with this? I mean, is there a dollar amount where I remember people used to say they called this like the poor man's will, and that if all you had was a retirement account and a house, that you really didn't need a lot of estate planning. What are your thoughts, and what kind of dollar amount should people be working with if they have, what asset level should they be concerned with?
Well, first of all, in Washington, we have a much lower estate tax threshold than we do on the federal level. It's around $2.2 million, $2,193,000 to be exact. So when the IRAs start getting into the $200,000, $300,000, $400,000 range, they're significant assets. And to simply leave those to the winds, so to speak, to draft a beneficiary designation when you first set the IRA up and then set it and forget it to an extent is not an effective planning strategy. So I would say probably somewhere in the $200,000 to $300,000 range, someone should start thinking about how that IRA is going to pass.
That's a pretty low threshold.
It really is. But when you think about the fact, particularly with the traditional IRA, you've got $200,000 to $300,000 of income sitting there as well. It's not merely an estate planning issue. It becomes an income tax planning issue as well. So I think trying to get the maximum amount possible to your beneficiaries with the lowest income tax hit, right around the $200,000 to $300,000, I think it becomes well worth people's time to put some thought into that and make sure the plan does incorporate that.
What happens if you don't name a beneficiary on your IRA? You've taken all the time to put together your estate documents, your will, your power of attorney, your living will, your healthcare directives, but then you forget the beneficiary. What happens in that kind of situation?
It really depends on the IRA contract. Some IRA custodians in that IRA contract that you signed, you read maybe the first couple of paragraphs of, you signed at the end and you went on, will call for an IRA to pass to a spouse, to children. That'll have a beneficiary designation kind of in place for you in the contract. And sometimes that can be a lifesaver. If the contract itself is silent, then that IRA is going to pass to your estate. And from an income tax point of view, that can be somewhat of a disaster.
So if it passes to the estate, are we talking 100% taxable all at once, or do we still get some stretch options when it goes to the estate?
It depends. And I'm going to say also that the Secure Act has thrown a bit of a monkey wrench in this, in that we're not entirely sure right now how that works.